All rise. Supreme Court of Law is in session. Honorable Chief Justice Robert J. Torres presiding.
Today, good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA24-004, People of Guam Plaintiff Appellee v. Ben Castro Crisostomo, Defendant Appellant. Appearing for Defendant Appellant is Attorney Shannon Titano. Appearing for Plaintiff Appellee is Attorney W. Lyle Stamps. The panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Titano reserves 5 minutes.
You may proceed, Ms. Titano.
Mr. Chief Justice and Associate Justices, may it please the court. This appeal stems from 3 issues. One is a claim of a conflict of interest that the trial counsel had that violated Crisostomo's Sixth Amendment right to counsel. The second issue is the prosecutorial misconduct for improper vouching. And the third claim is improper bolstering of the victim's credibility by the government. Any one of these errors warrant reversal, but together they demonstrate that Mr. Crisostomo was denied a fair trial in violation of his due process protection. The first issue is the conflict of issue. By denying trial counsel's motion to withdraw, it violated Crisostomo's Sixth Amendment right. Under the Sixth Amendment, a defendant is entitled to adequate and conflict-free representation. The existence of competing interests potentially affecting counsel's capacity to give undivided loyalty to his client's interests is an actual conflict.
So Ms. Titano, as I understand the government's argument and apparently persuaded trial court, it was argued that the witness PC, or I'm sorry, the person that created the alleged conflict, PC, was not a defendant, wasn't a victim, wasn't. There was no plan on the part of the government, at least that's what it asserted at the trial court, to be a witness. And so is the proper focus on PC to determine whether there's an actual conflict? Is that the proper focus to determine whether or not the defense counsel, in this case, APD, had a conflict of interest?
Your Honor, if I understand the question correctly.
I mean, I understand that PC had a role in determining whether or not APD was able to carry out its responsibilities. But I'm just wondering if the trial court did a proper analysis of determining that there was no actual conflict of interest. Because the trial court, as I understand, focused on PC's role, not being a defendant, not being a victim, not being was not going to be a witness in the trial, and therefore determined that the APD had no conflict of interest, apparent or actual. And I'm just wanting to know if that's the proper focus. And so I guess my question is, would that compromise APD's role as a lawyer for Crisostomo in reference to their his or her responsibility?
Yes, Your Honor. And the reason why I say yes is because although PC wasn't listed as a witness on either witness list, there was a conflict of interest that impeded defense counsel ability to adequately defend his client. And I say that because at the time of the motion hearing, it was relayed to the court that PC was a former client. Wasn't clear whether it was gonna be or it was a current, but they're under the rules, under Rule 1.9, there's a duty to a former client. And in the case below, what the defense was gonna argue was that the victim was lying in that Mr. Crisostomo wasn't the one that committed the crime, but PC was, and it's in the record where it was disclosed to the court that PC was the one that actually committed the crime, and they were going to use exculpatory evidence to try and impeach the victim. In the trial record below, that didn't happen. And so there's a probability, a reasonable probability, I would submit, that due to the conflicting or competing interests between by implicating the former and the current client, that there was an actual conflict of interest.
So by your statements, then you're suggesting, or you're probably saying, that the focus, the analysis should be on APD, the lawyer, as to whether or not there is a conflict in reference to a lawyer being able to do his or her job.
Yes, Your Honor, I would agree with that statement.
And is that what the trial court did in this particular case?
I believe the trial court, based on the information presented at that time, was looking at whether PC was an actual, going to be called as a witness, and looked at whether there was a similarity of the cases. And I believe that the trial court stated or decided that because PC wasn't involved in the allegations pertaining to Mr. Crisostomo, that there was no conflict. But under Libby, that inquiry may not have been sufficient. And at the time that the trial court heard the motion to withdraw as counsel, APD had also filed a motion to compel discovery. And according to the trial record, after discovery, the government did not provide any exculpatory evidence. But regardless of that, defense counsel filed a motion to compel, same time as the motion to withdraw as counsel, asking specifically for any police reports that named JW as a victim. And it wasn't until the morning of trial that this police report was disclosed to trial counsel. And maybe at that time, the trial, there should have maybe possibly be a renewed motion to withdraw. And maybe the court at that time should have done a more adequate review of the claim of conflict of interest, since there was disclosed to trial counsel at that moment exculpatory evidence naming a former client in a case involving similar accusations by the same victim.
How did that evidence come out at the trial level? Was there testimony? Was there sealed evidence where, in terms of pointing the finger at PC and alleging that he may be the one responsible for some of the actions that were blamed at Mr. Crisostomo?
I believe that there was a police report dating back to 2021, or where the alleged action occurred in 2021 by PC, and the victim in this case, and eventually a magistrate complaint that came out, I think, a few weeks after trial begun, alleging that that PC or was charged with the same allegations that Mr. Crisostomo was charged with in this case, namely terrorizing and I believe aggravated assault.
Now, the counsel for APD at the trial level, when all this came about, as I understand the record, said that he would use this information in cross-examination and never did, as I understand the record. Does this make any difference as to whether or not his ability to effectively represent his client and was compromised if he did never use the information?
I think it definitely demonstrates that his ability to adequately or effectively represent his client in that case could have been compromised by using exculpatory evidence that named a former client to try and impeach the witness in this case. And for that reason shows that there was an actual conflict that affected trial counsel's ability to adequately.
Well, I understand that that's the argument, but my question is, did he counsel at trial use the opportunity to carry out those responsibilities?
I believe he asked the victim about PC and there may, I believe, a question regarding similar allegations, but he did not at any time produce any evidence to try and impeach the victim witness at the time. And my argument is that that shows that his competing interests between a former client and the existing client. But no, to answer your question, he never tried to use any evidence to impeach the witness.
Does that affect the analysis as to whether or not there was an actual conflict of interest?
I think it helps demonstrate that. Well, it demonstrates that because there was an actual conflict in representing Crisostomo and the information he had regarding a former client. What is an actual conflict of interest? Because under Libby, the court has said that competing interests that potentially affects the trial counsel's capacity to give undivided loyalty to his client is an actual conflict of interest.
I understand, and the only reason I'm pressing this and asking is I didn't recall anything in the record that defense counsel was denied the opportunity to use the police report and use the police report in reference to pointing the finger, coming up with exculpatory evidence potentially at someone else, and that defense counsel was denied that opportunity. I'm just trying to work this through in my mind.
Yes, Your Honor, I agree. With you that the record shows that defense counsel had an opportunity to use the police report to try and impeach the witness in their testimony, especially after the few questions he had regarding PC with the witness, but he didn't do that. And my argument is that it demonstrates his
inability, or that he was because of his apparent conflict
Right.
representing a former client under Rule 1.9, that was not permissible. And I'm just wanting to see if there's anything in the ref that reflects that.
not specifically, I'm just making the argument that it demonstrates it. I don't think there's anything concrete other than you can infer from that he was unable to adequately represent his client because of a dual representation conflict that that the attorney felt he had, that there was a conflict.
The government says that you failed to identify the harm that resulted from the alleged conflict and that there has to be proof of a harm and prejudice that has to be proved, and that you have not proven how he was prejudiced.
Well, Your Honor, if I may, I believe that the government's argument is based on a Strickland analysis. And because there is an actual conflict, I would submit that it's a Sullivan analysis. But to answer your question, because this case rests on the credibility of the victim and the statements that from Mr. Crisostomo that refute the victim's testimony, that if trial counsel, absent the conflict of interest, was able to use that police report or exculpatory evidence to impeach the witness victim in this case, that Crisostomo was harmed and that the outcome could have been different.
Can you clarify for me, though? I mean, I thought the argument was that PC was the alleged perpetrator who caused the injuries, and it wasn't Crisostomo, not that he had concocted or she had concocted similar allegations against someone else previously.
So based on the record, the argument presented was that because PC was charged or alleged to have committed crimes against the victim similar to what the victim has alleged against Crisostomo, that the defense strategy was to discredit or impeach the victim and state that all the allegations that she made against Mr. Crisostomo were false, and that any crime committed against her was actually committed by her ex, Mr. PC, in this case.
Just to be clear, just follow up on the Chief Justice's question, when you pointed out a distinction between a Sullivan and a Strickland analysis, what is the difference?
So Sullivan stands for the proposition that if there is an actual conflict that affected trial counsel's ability to adequately represent his client, that prejudice is presumed. Under Strickland, the argument is if there's a potential conflict that a potential conflict that affected the outcome of the trial. Is my excuse me?
No, I agree. I just wanted to finish your sentence. For
Oh,
you.
sorry.
Just
Thank you,
make
Your
sure.
Honor.
But you pointed it out clearly.
Thank you, Your Honor. So it is.
Could you explain what you think the testimony should have been if he was challenged? I'm not sure I quite understand why this would be exculpatory evidence.
Well, my understanding was the police report had allegations against PC that were similar to what the victim was alleging against Crisostomo. So if trial counsel, while asking the victim about the allegations she made against Crisostomo, whether trial counsel would then recite the allegations contained in the police report to try and refute JW saying and accuse, well, to demonstrate that she was lying in her allegations against Crisostomo, being that the accusations were similar.
But that's where I'm a little unclear, because at the pretrial conference, I thought the argument was that the allegations against Mr. Crisostomo were actually committed by PC. That was what was made at the pretrial conference.
Yes, and so, so APD represented to the trial court that the allegations that JW made against Crisostomo were actually committed by PC, and that the allegations she made against Crisostomo in this case were lies, basically, that they were untrue.
So that statement then was not that PC actually committed the assault that allegedly occurred on the day that Crisostomo was hit with the hammer, but that he had similar allegations previously.
Correct, Your Honor.
Okay, because it wasn't clear just based on that argument that the allegations against our client were actually committed by PC, suggested that PC was the perpetrator in the same incident.
No, yeah,
Okay.
it wasn't the same instant. My understanding is that because PC had made similar crimes against the victim made up a story similar to what may have occurred to her when PC allegedly committed those crimes against her, against Crisostomo. And so it was APD's defense strategy to try and use exculpatory evidence regarding PC to discredit the witness in this case. And because of his APD's duty to former clients, arose a conflict of interest that affected the adequate representation of Crisostomo.
Does it matter whether APD obtained any confidential information during its representation of PC?
Well, that also, I'm glad you brought that up, Mr. Chief Justice, because that was in the motion to withdraw, that they couldn't make any further arguments for fear of violating any rule of confidentiality. So any information that they may have obtained in confidence under an attorney-client relationship could not be used in the Crisostomo case. And so based on the representation in the motion or in the declaration attached to the motion, there may have been confidential information that prevented trial counsel from adequately representing Mr. Crisostomo in the trial court case.
At the time of the trial, was PC a former or a current client of APD?
So APD represented during the motion hearing that PC was a former client, but he was arrested prior to the incident in this case. A magistrate complaint came out after, so it wasn't quite clear if he was also a current client. I don't know if that was the confidential information that APD was referring to in its motion, but it became aware of this conflict of interest, whether it's former or current client during the trial process below. So it is our position that there was an actual conflict, Your Honors, that impacted trial counsel's ability to adequately and effectively represent Crisostomo in the trial court case below. The second issue that we present is—
Before you leave that, I'm sorry, I know your time is limited, but I just wanted to finish that conflict of interest line of questioning. And assuming that there was a conflict of interest on the part of the defense counsel in this case, does that recuse the entire office, or is it just limited to defense counsel who was trial counsel at the time?
I submit that it disqualifies the entire office under Rule 1.10 of the Professional Rules of Responsibility, which is the impugning the entire office when there is a 1.7 conflict, which is duty to an existing client, and 1.9, which is a duty to former clients. So
And I
both,
asked that because I don't think I read anything that 1.10 was implicated. It's just that the conclusion that the entire office should have been recused.
yes, Your Honor, it wasn't raised in the arguments or in the motion papers or declarations in support of the motion papers by trial counsel. But I submit that Rule 1.10 would apply, being that they claimed there was a conflict under 1.9, and 1.9 is expressly included under 1.10 to disqualify the entire office.
Thank you, counsel.
Thank you. The second issue, Your Honor, is an error regarding the prosecutor improperly vouching for the victim's credibility during closing argument. Again, this is a case regarding credibility. The challenge statement in this case is by the prosecutor during closing argument. It should also be noted that despite Ben's denials, the police arrested him, not JW. If JW was lying, why didn't the police arrest her? Question mark. This clearly places the government's prestige behind the witness through police authority. Not merely is this a statement summarizing the evidence, but it's an actual invitation for the jury to defer to the law enforcement, to police's discretion to arrest an individual for probable cause, which does not necessarily mean the truthfulness of the, in this case, victim. This, again, is particularly prejudicial, Your Honors, because credibility is a central issue in this case. No curative instruction was given after the comment was made, and the Mendiola case, in the Mendiola case, it states that a general jury instruction reminding jurors that lawyers' closing evidence may not be sufficient since there was no curative action made immediately after the statement to ignore the statement and remind jurors of their roles.
So what was the proper standard of review in looking at this alleged error?
I would submit, Your Honor, that it's plain error since there was no objection, that this is clearly vouching, that which is the error that affected the substantial rights of Mr. Crisostomo. It's similar to the Mendiola case that I had cited to, where there wasn't, in the Mendiola case, there was actually no evidence other than the victim's testimony. Here, there's minimal evidence, and then coupled with the victim's testimony, but being that there's, the argument is credibility or credibility.
But I don't recall that you addressed whether or not there was prejudice in your analysis of, did you address this in your briefing?
I believe I did, maybe not as extensive as the court would require of me, but I would submit that there was prejudice similar to what happened in the Mendiola case, which found plain error for due to the misconduct by the prosecution in vouching for a witness where credibility is the crux of the case.
You have 3 minutes left, just to let you know.
Thank
So I
you.
don't know if you want to reserve or address the bolstering argument now, or
I can quickly go through bolstering, Your Honor, being that, again, also being that credibility is the crux of this case. In this instance, Officer Villanueva improperly bolstered the victim's credibility when asked whether the victim was lying. And in response to the prosecution's question, she said that to Officer Villanueva, that the victim was telling the truth. That is bolstering. There are a line of cases that support that, Roten being one of them that comes to mind. The statement served no other purpose but to enhance the victim's credibility, and law enforcement testimony carries a particular weight with the jury. And it's the jury's role to determine the credibility of the witness, and by bolstering, by the statements given by Officer Villanueva, I submit that it usurped the jury's role in this case. And
All right, thank you. We'll give you 2 minutes on rebuttal.
thank you, Your Honor.
Mr. Stamps?
Morning, Your Honors. May it please the court. I'm arguing this case today instead of Mr. Cole. He was not feeling well this morning, so I apologize to the court in advance. I may not be able to assist in sharpening the court's jurisprudence on this issue, but I will do my utmost to answer the court's questions. As an initial matter, I think one issue that was brought up right away was this issue of the conflict of interest and what should be done if there's Rule 1.10 is implicated. And I would just like to briefly point out, as this wasn't briefed, but looked it up, and under 1.10, that is a prohibition unless, number one, under Rule 1.10, the prohibition is based on a personal interest of the disqualified lawyer and does not represent a significant risk of materially limiting the representation of the client by the remaining lawyers in the firm. In the instant case, Mr. Santos and Ms. Gale had both represented the defendant at trial. Mr. Santos was handling the trial itself. However, I would respectfully submit to the extent where Mr. Santos had indicated that he had represented PC previously, that did not, any personal knowledge that he would have gained unless there was a proffer and evidence presented to the court to show that that information was also made available to Ms. Gale at the same time and that she represented that person, that there is no need to disqualify the entire firm. I think this court's jurisprudence on this matter, this is an issue that comes up all the time about due to the size of the bar here in Guam. This is not a new issue. And I don't think
There was no information that there was appropriate screening of one lawyer from the other or information. In fact, Attorney Gale had indicated she had confidential information from her representation of PC, right?
No, that was my understanding, and I could be incorrect about the record, was that was information that was provided by Mr. Santos, so that Mr. Santos may have had additional.
No, I thought he said he did not have any confidential information. But Ms. Gale was the one who represented previously that she had. I think that.
And if that's the case, Your Honor, then
Does that change the analysis then?
I think that potentially does change the analysis if it's an actual conflict. The problem that we're facing here, the words used were probability or infer. And that's what we're stuck with, unfortunately, is because this information wasn't brought out. I think it's clear now how to handle the fact that additional information was not placed on the record and brought to the court.
Well, does that suggest the court then should have conducted a more extensive hearing under Libby?
I don't believe so, Your Honor. I think that falls under, I would respectfully suggest that was APD's duty. To the extent that they came into possession of new information, it was their duty to bring that to the court's attention again. So, for example, there was mentioned that there was potentially exculpatory evidence for another charge related to PC. And yet that wasn't brought up. Trial counsel could have easily asked for a sidebar and brought this to the court's attention outside of the court. They could have filed another motion. They didn't do so because they didn't bring that information to the trial court. We have the record that we have, and we're stuck speculating. I would respectfully submit that speculating about a conflict is not the standard that this court wants to set for whether or not there's a conflict of interest that creates a conflict that impaired trial. We're speculating. Well, maybe they didn't go into this because of that. Well, if that's the case, there's an easy remedy. And the easy remedy is that should have been brought to the court's attention through sidebar or motion. It wasn't. And because it wasn't, then there's no need for this court to speculate. And Well, I would
But wasn't
suggest-
what that was what they were trying to do at the onset by moving to withdraw? By asserting that the argument was that the allegations against their client were similar allegations that she had raised against another client of theirs? I mean, that was their basis for moving to withdraw.
And to that extent, Your Honor, I think as additional information they became aware of the additional information and they didn't use that additional information. Again, the trial court could only act upon what was given to it. So respectfully, I would suggest that was APD's duty to do that. So that we're not stuck in a situation where we're speculating. But there's no need to speculate because in this case, the standard is respectfully under, I would say.
But
Yes,
Attorney
sir.
Gale filed a document under seal that said the theory is that the victim's lying because what Crisostomo had done to her it was similar to what she was done by her former boyfriend. And she did not want to reveal attorney-client privileged information and therefore wanted to withdraw. So the argument I think that she was making, or the argument that's being made by Ms. Taitano, is that when it came time to cross-examine JW about the event, and specifically looking at PC's role in the prior incident, they did not zealously pursue cross-examination of her because of the implication of PC, who was a client, and they had competing loyalties.
And if that is the case, Your Honor, then again, respectfully, I'd suggest that they should have brought that up via sidebar or a motion, a renewed motion with the court to bring the additional evidence.
But if they failed to do that, does that mean you're saying that they've waived that ability to bring that issue? If counsel has a conflict and does not cross-examine the witness on the stand with evidence that potentially could be exculpatory because he has a duty to another client or feels he has a duty and of course doesn't raise it to the judge, are you saying he's required to raise it, and if he doesn't do it, they forfeit that issue?
Your Honor, I would suggest, it sounds like I might have misunderstood the record. It sounds like it was, as you pointed out, it was Attorney Gale that had the conflict and not Attorney Santos. Again, in this case, I suggest that conflict does not necessarily mean that it goes to Attorney Santos, and that he especially could have brought that up. She might not have, and that sounds like
APD was the appointed counsel. I mean, and so wouldn't there be an imputed knowledge on the part of one attorney employed under APD who's representing, and without a proper conflict wall, that that would be an knowledge that would be imputed to the other counsel?
not necessarily, Your Honor. And again, I think if this matter would be easily resolved if there were facts on the record to demonstrate that. As it is, we don't have facts on the record that show that any knowledge that Attorney Gale might have had was transferred to Attorney Santos. Presumably, APD has sufficient conflict walls in place, as have after the last few years.
Well, that's your burden that you should have, that should have been raised, but I mean, the argument here that Ms. Steiner is making is that as a result of the APD representing as a former client, PC, that their ability to zealously represent Mr. Crisostomo was compromised because because of the dual loyalties under Rule 1.9. And therefore, that may have been the reason, and that's why I was pressing, what is the evidence that this in fact was the case, but that being the case, the argument is being made that the APD's lawyers were compromised of their ability because of their dual representation of PC, a former client, and Mr. Crisostomo. And under the rules that there is an actual conflict of interest that compromise the ability of APD to represent Mr. Crisostomo.
And yeah, I would agree with you, Your Honor, that is, we have the potential that that's what's happened, but we don't have that evidence of record. And because that evidence was not raised and could have been raised, then yes, I would agree with the Chief Justice that was waived. As to the remaining issues, Your Honors, if there's something in particular, I believe that the briefing by Ms. Rees was sufficient and adequate, but I'm happy to try and address any questions that the court may have. I think the record is very clear that as to the other issues, that there was no improper remarks by the prosecutor, because they were simply drawn from the evidence, and where the prosecutor created a summary, which is what we do. We create a summary, we create a story based off of the evidence that's presented. And the very next statement by the prosecutor was to remind the jury that they're the ones that make that determination as to truth.
What about Officer Villanueva's testimony? I mean, even the trial court seemed to be bothered by that and brought it up that it was vouching, and the attorney said that he wanted it to continue because he would cross-examine Officer Villanueva, and then didn't do that.
I think that's an excellent point, Your Honor. I'm glad you raised that. I think that's another good example of counsel have to make decisions at trial. They make tactical decisions. Counsel decided that they would rather take advantage of that and try and expose the officer on cross-examination and impeach them, and that was their strategy, that they would get more out of that than a bolstering instruction from the judge. But
then they didn't proceed to do that, though.
Then and that happens before. I forgot to do things. We've all forgotten to do. If we make a mistake, we make a mistake. Or maybe it wasn't a mistake. Maybe, again, we don't know. What we do know is what's on the record. And the record says he laid out his strategy for how to deal with this issue. That he didn't proceed with that. That's not, he decided to do it a different way. Well, honestly, we don't know. And I don't think it's particularly relevant, because the trial court might have been bothered by it, but the opportunity was there for it to be corrected.
Well, Ms. Steinville pointed out that it was extremely relevant and prejudicial, because this came down to he said, she said, in terms of credibility, and credibility was supposedly undermined. And in terms of the police officer bolstering the testimony of the witness. And so that's the argument that Mr. Crisostomo's substantial rights under a plain error review, he was extremely prejudiced as a result, because it was a credibility issue, and you had the weight of a police officer seemingly pointing out and saying this witness is telling the truth. Doesn't that affect the analysis of taking away the issue from the jury in terms of weighing who is telling the truth by a police officer indicating that as a result of these statements, it's more than likely that the witness was telling the truth?
Yeah, I would suggest instead, Your Honor, as we did in our brief, that the officer was merely describing their observations of the victim's demeanor and consistency when recounting the events. The officer's statements didn't pertain to identifying the perpetrator, They didn't invade the jury's role in assessing
But
truthfulness.
that wasn't the issue. The issue is one of credibility. It's not identifying any perpetrator. It's just taking away seemingly the argument, the issue from the jury as to who is it that is telling the truth by putting the weight of the government behind the witness, that this witness is telling the truth, and therefore the jury is likely influenced by that. That's the substantial prejudice that is being argued, as I understand the argument that Ms. Dyton was speaking.
I would agree, there's always that potential for concern about that, Your Honor. However, at the same time, that same concern arises in every case where you have a police officer testify that there's going to be that the jury is just gonna, okay, well, the cop said that's what happened, so that's what happened.
Yeah, but in this case, the police officer is testifying as to the credibility of the witness, not the jury determining from testimony whether or not the witness is telling the truth and making that independent analysis, review, and determination.
I would just respectfully submit, Your Honor, that the jury remained free, and it still remains free, to take that piece of testimony and evaluate it on its own, whether or not the jury chose to place any credibility in the officer's testimony or not.
Was there any jury instruction to the effect that the additional testimony of the officer vouching, bolstering the testimony of the witness should be discounted, and you should independently evaluate testimony?
Again, I believe the records we just discussed, Your Honor, was that the offer was made and defense counsel declined that.
I'm not understanding what you're. What are you referencing when you say that?
Maybe I might be mixing these up, Your Honor, one moment. My apologies, Your Honor. I may have confused that with the prior issue. However, again, I would, to attempt to answer the question, is that, again, it suggests that Officer Villanueva's testimony didn't relate to the identification of the perpetrator or to necessarily to credibility. And that if we were going to impose that steep a standard upon them, that we would effectively make testimony from law enforcement almost impossible for them to present any of their observations. Number one, and number two, that in our society, I think we've gone for some of these standards were developed in a time period when, yeah, there was a lot of respect for police officers, for the court, and for government. Unfortunately, in the times that we've been in for several decades now, that same level of respect, unfortunately, I don't think exists. And so I think the court may, I mean, that is the court's prerogative, and we're glad that you're here to do that, is to weigh those, very deep, important issues and whether or not there is some type of improper influence. I think it's important to keep in mind, however, that some of those fears may not be as present in our society today as they once were.
So you're saying that we've evolved such that how a jury in the 1800s, 1900s viewed the testimony of police officers is no longer heightened and as influential as what it is today now? Is that what you're arguing?
I would suggest that might be something that a policy consideration that the court would take into account.
Do you have any basis to make that assertion?
Nothing other than my personal experience, Your Honor, as a practicing attorney and as an individual on the street, and those things that I read and see, and that I know that the court and every person has different experiences. As a personal aside, perhaps, I remember when I was certainly raised to have a deep respect for law enforcement and to cooperate and to trust what they said. And so
So if
30
if the jury was to take that, the same feelings and opinion, and you had a police officer testifying that that witness is telling the truth, then wouldn't that carry more weight and prejudice potentially the defendant in taking away from the jury whether that it should make that independent analysis free of a police officer saying that the witness is telling the truth and making that determination on its own?
I think, Your Honor, I think that we're safe to trust the jury to be able to make that determination, and that they're not going to be unduly influenced by that. That was the first half of my experience. That's what I was raised with, but my personal experiences after that time were filled with, let's just say, jokes that wouldn't be appropriate about, what police officers like to eat and their trustworthiness and whether or not they're, what they're doing, the number of tickets being given out and why they're being given out. I think there is a much greater and heightened scrutiny and awareness on the public's part about the fallibility of our institutions.
All right, there's nothing further. Thank you, Mr. Stamps.
Thank you, Your Honor.
You have 2 minutes, Ms. Taitano.
Thank you, Your Honor.
I have a question. When the judge decided that there was no conflict of interest and kept the APD on, was that a finding of fact or was that a conclusion of law?
I recognize when determining any conflict of interest, it's a determination of fact and conclusion of law analysis. I believe it was read on the record. The judge indicated she would issue a DNO, but all the record indicates is that based on the fact that the former client wasn't going to testify in the existing case, and that APD did not, for fear of disclosing any confidential information, determined that there was no conflict of interest. And following that question, Your Honor, I would submit that the inquiry below was inadequate under Libby. In Libby, there was an extensive questioning by the defendant and the attorney to try and determine whether there was an actual conflict. But the court rendered its decision on the representation that PC wasn't going to testify in the case. And there was, for fear, I guess, of disclosing confidential information, there was no other representation from APD showing that there would have been a conflict of interest, Your Honor. These errors, including the bolstering and vouching by law enforcement on where credibility is the crux of the matter, these cumulative errors, I would submit, warrant reversal and remand because they demonstrate that Crisostomo wasn't given a fair trial below. Your Honor, I submit my case. Thank you.
All right. Thank you, Ms. Taitano. Thank you, Mr. Stamps. The court will take the matter under advisement and will issue a